Good morning, everybody. Hopefully everyone can hear me. Welcome to the continuing professional development session on impaired driving consequences, both territorial and federal. For those who don't know me, my name is Lauren White. I'm a member of the Continuing Professional Development Committee of the Law Society of Yukon, and I'll be moderating today's event. And just so everyone knows as well, before I get into the introductions, this session is being recorded. So if you miss anything, it will be posted on the Law Society website and you can go back and watch it later. So it's my pleasure to introduce the panelists today. First to talk will be Leo Lane. He's been a prosecutor since 2008. That's him on the left side of the screen there. He spent his first 5 years in the Nunavut office of the Public Prosecution Service of Canada and then transferred to the Yukon in 2013. Leo helped train fellow prosecutors and RCMP officers on the sweeping revisions to the driving sections to the criminal code in 2018. Since then, he's increasingly focused his practice on impaired driving prosecutions and appeals. Leo has been trained to operate breath and oral fluid testing devices, such as the Intox EC/IR2, the Elco Sensor FST, and the Abbott Sotoxa. Our second speaker today will be Kelly McGill. Kelly was called to the bar in 2013. She spent 3 years at a private law firm where she had a general litigation practice focusing on family law. In 2015, Kelly joined the Yukon Department of Justice litigation group as legal counsel. In this role, Kelly is part of a small team of lawyers that conduct prosecutions for regulatory violations under territorial statutes, including the Motor Vehicles Act. Kelly also acts as counsel to the Registrar of Motor Vehicles. And our last speaker today will be Julius Debuschwitz. He's now retired from a government career in transportation safety and enforcement that spanned 41 years in Alberta and the Yukon. During that time, he served on numerous national and international committees, including the Canadian Council of Motor Transport Administrators and the Canadian Education Quality Assurance Team. He's had numerous articles published in national and international publications, and he's instructed in Canada and the US and was Yukon's acting chief coroner from 2004 to 2014 on a part-time basis. He is currently serving a 3-year term as the chair of the Driver Control Board in the Yukon. So welcome and thank you to our panelists. What we're going to do today is each speaker will present individually. While they're speaking, I'm going to be monitoring the chat function on this Zoom platform. So if you have a question at any time, please feel free to put it into the chat box and I'll be interrupting the speaker to ask them your question. So don't be shy about throwing questions into the chat box. So without further ado, Leo Lane will be going first.
Thank you, Lauren, and good morning, everyone. I'm just going to share my screen here and bring up PowerPoint. All right, so just a couple of comments on the title of today's presentation. We've called it Impaired Driving Consequences. It should be clear from the more detailed descriptions of the topics, but what we're talking about by consequences is the consequences for individuals' driving privileges. So if you were hoping to hear about other consequences like fines and incarceration, sorry to just disappoint you, and if you want to disconnect, I won't take it personally, but we're going to be talking about driving privileges primarily. And also the term impaired driving consequences is a little bit of a misnomer. We're using it as a sort of a catch-all term, but we are going to be covering other driving offenses in the Criminal Code and the Motor Vehicles Act, including dangerous driving, flight from police, essentially. Our subject today is the interaction between the code provisions and the Yukon statute, which includes the Driver Control Board. And before I start going through my slides, a bit of an anecdote. So what inspired this presentation in part was a case that one of my fellow prosecutors conducted, where a person was pleading guilty to the offense of dangerous driving in the criminal code. And the defense and the Crown were jointly proposing a jail sentence, but it was going to be intermittent jail, so just serving time on the weekends. And the purpose was so that the offender could keep their Monday to Friday job. And their job required them to drive. So the plan was also, while they were not in custody, to allow them to keep driving for work. The Crown was not seeking a full driving prohibition, which was discretionary under the code. But the parties agreed that their driving privileges should be restricted so that they would only be driving for employment purposes. And what they proposed to the court was that this would be done through a probation order, which would take effect in between the jail periods of jail. And so in the days and weeks leading up to the sentencing hearing, the lawyers went back and forth, worked out all the terms of the order, things like, you must not drive except directly to and from work or while working, specified the days of the week and the hours of the day that the person was allowed to drive, and came up with a fairly detailed order that they hoped would cover all of the possible scenarios and be enforceable. And they went to court, judge heard the submission, agreed with the lawyers, and imposed the intermittent jail and probation order. But what everyone at the sentencing hearing had missed was one crucial detail, which is that the Motor Vehicles Act, the Yukon Motor Vehicles Act, stated that everyone who is convicted of dangerous driving under the code is disqualified from holding a license for at least 3 months from the date of conviction. So all that effort that the lawyers had put into negotiating that the conditions and making sure that the offender could keep their job was completely moot. The person just couldn't drive for at least 3 months period. And so obviously not an ideal situation for the client, a major impact on their livelihood, and problematic for the lawyers as well, as it undercut an important objective of the joint resolution that they had come up with. And so one of our purposes today is to help practitioners avoid these kinds of nasty surprises or unintended consequences by being more aware of the various ways in which the federal and territorial driving statutes are linked. So I'm going to be focusing on criminal code driving prohibitions. There are two types. There's mandatory and discretionary, and we're talking about sentencing provisions here. So the mandatory prohibition order is found in 320.24 sub 1 of the code. As I said, it's sentencing only, so it's only after a finding of guilt has been made. And the offenses that it applies to are the various impaired, impaired by alcohol, impaired by drug, or the blood the blood, alcohol, or drug concentration offenses. So the most common being at or over 80 milligrams of alcohol, but the various drug concentration offenses as well. And one key factor is that these are just the simpliciter offenses. And by that, I mean not cases involving bodily harm or death. Now, it's amazing odd, but Parliament has chosen to make the prohibition order mandatory for the simpliciter offense and discretionary for the more serious offenses causing bodily harm or death. And we'll get into maybe one of the reasons for that in a moment. But this is just for the simple offenses of impaired and related offenses, as well as refusal of a lawful demand from a police officer to test breath or blood, or comply with basically forensic testing for substances. So the refusal offense. So for all of those offenses in the code, a prohibition order is mandatory. And the mandatory prohibition order carries with it minimum and maximum length. So the duration as calculated in the code is, it changed a little bit since 2018, but the duration is given as the appropriate prohibition length, whatever that may be for the offense in question, plus the entire period of imprisonment. So if the judge thinks that the sentence deserves, or the offense deserves, a 2-year prohibition and 6 months jail, then the entire prohibition order will be 2 years, 6 months in duration. And there's an increasing range for this offense. So for a first offense of the ones that I listed on the previous slide, first offense, the prohibition is a minimum of 1 year. That hasn't changed. That didn't change with the 2018 amendments, and a maximum of 3 years. For a second offense, minimum of 2 years, max of 10. And then for third and subsequent convictions, it's a minimum of 3 years and no maximum. So the court can impose a lifetime driving prohibition under the code. Now, the discretionary prohibition order found in section 320.24 sub 3 to 4 applies to various other driving offenses. The first one, the blood drug concentration offense. That one is currently prescribed as a person having 2 nanograms or more of THC per milliliter of blood. Dangerous operation. And here we get the impaired or refusal offenses where death or bodily harm is caused, as well as fail to stop after an accident, flight from police, and operation while prohibited. And that last offense is changed in 2018. Previously, the offense of operation while prohibited carried a mandatory minimum prohibition order, so it was treated like an impaired, and now it is discretionary. Now, the discretionary prohibition order, as I said, doesn't carry a minimum, but it does have various maximums. So the low blood drug offense has no minimum, but a max of 1 year. Sorry. And then the other offenses, the maximum is worked out by looking at essentially the maximum prison sentence available for that offense. So using prison sentence as a proxy for seriousness of the offense, the maximum goes up accordingly. And so any offense where of the ones listed where the maximum is a life prison sentence, and those are only the ones causing death. It can also be a lifetime driving prohibition, where the maximum is over 5 years, but something less than life. And that would be basically any of those previous offenses where prosecuted by indictment. It has a 10-year maximum for the prohibition order, and then all of the other ones is a 3-year max. Now, when someone is being sentenced and receiving a driving prohibition, the Supreme Court held in a case called Lacasse from a few years ago that if they were prohibited from driving while on bail, judicial interim release, that period of prohibition has to be deducted from the sentence prohibition going forward. So the court does not have discretion on the current state of the law. And what Lacasse didn't deal with was what happens if the person is already at the mandatory minimum, or where after deducting credit, the prohibition would be dropped below the mandatory minimum. That wasn't the scenario in Lacasse, so the court didn't comment on it. But our own Judge Cousins from Territorial Court did consider that issue and found by reference to principles for mandatory minimum jail sentences, and when those can go below a mandatory minimum with pre-sentence credit, applied those principles to the driving prohibition scheme, and found that that the court can reduce a prohibition below the statutory minimum where the person has been prohibited while on bail. And so it's a territorial court decision. It's been followed. That's the Crown's office takes the position that that is the current state of the law in the Yukon. So it's basically followed here. The court in Bland also found that where a person has been had their driving privileges restricted not from a criminal code bail order, but from the Motor Vehicles Act, as Kelly is going to be talking about shortly, that period of time should not be deducted from the criminal code sentence prohibition. And so it wasn't really the focus of the Bland decision, as far as I can tell, has not been judicially considered since then. I can recall a few cases a few years ago where defense had at least raised the prospect of litigating that, but I don't know of any decisions that came of it. And so I guess it remains to be seen whether the Bland case holds up on that point. When does a driving prohibition start? So the criminal code is clear that it takes effect the day that it is made. Previously, following the CAS, the court said that a prohibition starts at the end of a jail sentence, which I think caught some people off guard because there were cases that went the other way and said that the language that Parliament used meant that it should start, it should follow the presumption for sentencing generally, which is that it takes effect the day that it's imposed. But the CAS said that Parliament did not intend that. And so in the 2018 amendments, Parliament came back and said, well, actually, we did intend that. And so they cleaned up some of the language, and now it's very clear in the code that it starts the date that it's made, subject to one exception, which I'll get into my second bullet here. And as I said, it's calculated by taking the period of prohibition and adding any term of imprisonment. Now, the code doesn't get into more detailed scenarios like intermittent jail sentences or conditional sentences, whether a conditional sentence is considered a term of imprisonment for purposes of a prohibition. And those have not been, as far as I can tell, have not been the subject of reported decisions in the country. I think intermittent sentences, I think it's safe to say that the court would just kind of ignore the fact that an intermittent sentence is spaced out over a much longer period of time and just look at the actual period of custody. So if it's a 60-day intermittent sentence, meaning 60 days of jail interspersed with periods out of custody, the court would just say, take the prohibition, add 60 days to it, and then it starts running immediately. That one should be fairly clear. Conditional sentences, I think, are much less clear. The term of imprisonment is not uniformly interpreted in the code. It depends on the context and the purpose for which it's used. And there's arguments to be made on both sides. So take the scenario where somebody gets a CSO of 1 year and a 2-year driving prohibition. One interpretation would say that the actual driving prohibition imposed should be the fit prohibition, which is 2 years, plus the conditional sentence, which is in some contexts considered a term of imprisonment, leaving a total prohibition of 3 years. I think there's an argument to be made that that's not what Parliament intended, that really what they were talking about is that somebody should not get the benefit, or not benefit, but should not have their driving prohibition reduced when they're in jail and can't drive anyway. But when somebody is out on a conditional sentence, and sometimes they're out on a conditional sentence because the court wants to keep them working, which may involve driving. So because the principles of sentencing for conditional sentences are different, I think an argument could be made that that period of time should not be added. But like I said, it's received very little attention. I think courts are kind of just dealing with it ad hoc. And so it remains to be seen how that's interpreted going forward. The one exception that the code recognizes to an immediate start for the prohibition is if an offender was prohibited at the time of the commission of the new offense. So they were on a previous prohibition, they committed a new offense that they're now being sentenced for. The court can make any new prohibition consecutive to the one that they're already serving. It's kind of peculiar language because it talks about being prohibited at the time of the commission of the offense. Now, by the time they actually get to sentencing, it could be a different scenario, or somebody could have committed an offense and then picked up a new driving prohibition, which is active at the time of sentencing, or they could be sentenced for multiple impaireds at once, which is not an uncommon occurrence. Somebody picks up a couple of impaireds, and then the court is sentencing them on all of them. What to do with these multiple new prohibitions, the code doesn't say. And so on a plain language reading, it doesn't seem like the code provides for consecutive prohibition orders. But I think a reasonable interpretation, looking at how they're treated elsewhere in the code, would suggest that they could be consecutive. And the prohibition order can also be stayed pending an appeal. And what the court has said there is that during the period of stay, the court can impose conditions on the driving. So they could, like the scenario I talked about at the outset, the appeal court could stay the driving prohibition, but say you're only allowed to drive for work, something like that. So kind of not prohibit it entirely, but restrict the person's driving to some degree. And what the code says is that if that's done, then those kinds of restrictions don't reduce the overall length of the driving prohibition. So it would, the one that was passed by sentence, if it survives the appeal, would remain intact. Now, what do we mean by driving prohibition? What exactly is prohibited? The criminal code talks about various vehicles, if I can call it that, or they're called conveyances, which includes a number of different things, including vessels, so boats, aircraft, railway equipment. A driving a prohibition for those is any kind of operation. But for motor vehicles specifically, the code states that a prohibition prohibits operation on a street, road, or highway, or in any other public place. So it's not a blanket prohibition of all kinds of operation, but it's on these types of places: street, road, highway, or other public place. And just a note about operation, from the definitions in the code, operation of a motor vehicle means actually driving it, so behind the wheel while the vehicle is moving, or having care or control, so having the ability to put the vehicle into motion, immediate ability to put the vehicle into motion. And so that phrase has been the subject of, the phrase "in any other public place" has been the subject of a fair bit of jurisprudence, because people, who are prohibited from driving rightly wonder, well, what is there any kind of driving I can do, or what kind of driving would be allowed under the prohibition? And so I've got a few cases here, and just so everyone knows, the PowerPoints will be posted to the website, and so you will be able to get these citations from the web, from the Law Society website afterwards. But where courts have found that any other public place applies, so where driving is prohibited, public place has been found to include things like the first one here from the Hagerman decision: person found on a snowmobile on a bush trail 35 kilometers outside of Fort McMurray. The court talked a little bit about the purpose of the prohibition and public safety, but there doesn't seem to have been much evidence on how often this bush trail was used, what kind of traffic it saw. Basically, the judge in that case said, if it's public land and the public has access, that's other public place. So it doesn't matter if you're outside of town on a snowmobile, that's a public place and you're not allowed to drive. Similarly, in the Haniliak case from Nunavut, and just as an aside, this provision has not been is not the subject of any written published decisions in Yukon. So that's why I've included all these cases from elsewhere. But the court in Haniliak, the scenario there was that a fellow was seen driving in off the land to his yard. By the time the police apprehended him, he was in his yard, which is private property, and clearly he would not be prohibited from driving in his own yard. But there was evidence that he came from somewhere else, and where he came from was basically the tundra on the outskirts of Cambridge Bay, because his house was basically the last one or in the municipality. And so the court followed Hagerman, found that if it's a place that the public has ready access to, that's other public place, you can't drive there, and talks about the need to maintain public safety and that there could be other people coming and going, that particularly in this remote northern hamlet, that's a primary means of transportation, snowmobile on the tundra. And so the court essentially found that because the public has access, that it's you can't drive there. In the Singh decision, the person was driving some kind of aviation vehicle. I can't remember if it was for moving luggage around or what it was, but they were driving on what's called the apron of the airport. It was Pearson, Lester B. Pearson Airport in Toronto, and they were on the tarmac side. And so it was a heavily controlled environment. The public couldn't just drive on there. You had to be approved by the airport authority. And so there was evidence of heavy use of that area, but also strictly controlled. So not what you would commonly think of as a place where the public would have access. But the court did talk about the fact that planes were using it and that public was on these planes, or passengers on the planes. And again, really relied on this public safety aspect and what is the purpose of a driving prohibition, and found that even though the public was largely restricted from free access to that area of the airport, it was still a public place. And so the conviction, the person was convicted. And then finally, on what locations have been found to be public, in the Dunsford case from Ontario Court of Justice, a road entirely on a First Nations reserve, which was not connected to the provincial public road system, was found to be other public place because it's used by the First Nations community and by people who are making like delivery drivers. I think the evidence was people were accessing the reserve periodically. And that conclusion is contrary to the one reached by the BC Provincial Court in Wycott, which says that a road on a First Nations reserve, it is accessible by First Nations community members, but not the general public, and therefore acquitted a person who was driving on it and said that the law did not apply, the prohibition did not apply to that area. So conflicting decisions there. Where locations have been found to be not any other public place, I've got two cases. In Ballard, there was a driver or an operator of a bulldozer on a portion of highway that was under construction. The area that they were driving the bulldozer on was technically closed. The public wasn't allowed to go there, but there was no physical barriers. But the court found that was enough, that it wasn't a place where the public would find themselves, and so that was okay. And then in the Maxwell decision from Northwest Territorial Court, the judge there conducted quite a detailed and nuanced analysis of the law and considered the cases from the previous slide that I was talking about, and didn't just say if the public has access, it's a public place, but instead came up with an interpretation that says that the public place means a place to which a significant segment of the public has a right of access, and where it can be reasonably anticipated that a motor vehicle that is being operated will come into close proximity to pedestrians or other motor vehicles. And so essentially putting the onus on the Crown, where this offense is charged, to call evidence as to the degree of traffic, whether a significant segment of the public has access to it. And in that particular case, there was evidence that somebody was driving in a campground, which was inside the municipality of Fort Smith, NWT, but there was an absence of evidence as to exactly where the truck was at the moment it was seen. And the court found that the Crown had failed to meet its onus on this interpretation of public place, and an acquittal followed. Now, the offense of operation while prohibited is found in 320.18. So what happens when you are prohibited and you're caught driving or operating some other form of conveyance? And what the code says is essentially there are three ways that this offense can be made out on my interpretation. It is arguable, which I'll get to in a minute, but three ways that this offense can be made out. So the first is where the person is prohibited by an order made under this act. And so the Crown's office locally has been taking the position that Parliament, by using that broad term, an order made under this act, intentionally included prohibitions imposed under bail conditions. Now, previously, before the 2018 amendments, this offense, operating a motor vehicle contrary to a release order or a recognizance or an undertaking, that could only be charged as a breach offense. And part of the reason for that is that the offense as it was structured said that it's an offense to operate a motor vehicle while prohibited by a particular section of the code, 259. Now, Parliament changed that language and said an order made under this act. Didn't say an order made under these sections, didn't say an order made under this part, which is the part that includes all of the impaired driving provisions, but said an order made under this act. And so the Crown has taken the position that that means because bail is covered under the criminal code, that includes bail conditions, that those should now be treated as the offense of operation while prohibited, not breaches. And then, of course, the other way that offense can be committed is by operating while bound by a sentence order. And again, the Crown takes a broad view of that. And sentence order would include just a simple prohibition, 320.24, or if a person is prohibited by the terms of a conditional sentence or by a probation order, the Crown is interpreting that to mean that is a prohibition as well. Now, the counter argument is that Parliament only meant prohibition as that term is strictly used in the code, and so no other forms of driving restrictions under the criminal code. And that has yet to be litigated in Yukon, and as far as I know, anywhere in the country. So there may be some judicial interpretation coming on that at some point if somebody gets charged while driving contrary to their bail conditions. Another argument could be that if the bail order doesn't outright prohibit driving, but just restricts it. So in the case of somebody who could drive for employment, is that what Parliament meant by a prohibition? And should that be treated as this type of offense, or should that be a breach? And then the other way this offense can be committed is not new. This was in the code prior to 2018 as well, where a person is prohibited by any other form of statutory restriction, so another federal act or territorial provincial statute, as long as it was imposed in respect of a criminal code conviction. So if you have unpaid tickets and your license is, sorry, Kelly, I'm going to get this wrong, whether it's suspended or disqualified. She's going to educate us shortly. But if your license has been restricted because of something that's not a criminal code conviction, but a regulatory restriction, then this would not apply. It's not criminal to drive while restricted in that fashion. But where the federal, or more commonly Motor Vehicles Act restriction is directly linked to a prior criminal code conviction, then breaching that itself becomes criminal. And we have seen a few of those. So that wraps it up. I've given my email address and phone number if anyone has any questions, and I'm going to pass things over to Kelly McGill. I'll just, if anyone wants to submit questions while we're transferring here, I can take those.
Thank you, Leo. I'm not seeing any questions in the chat, so
Do I share it?
as soon as
Sharing
Kelly's
already.
ready, we'll get going with her.
Oh, I know what I have to do.
Thank you. Hello, everybody. My part of this presentation is to talk to you a little bit about, as Leo said, about the Motor Vehicles Act, which is the territorial statute that regulates the privilege of driving in the territory. I'm not going to touch on all the sort of pieces of the Motor Vehicles Act. It's a big statute, but really focusing in on the interaction between the Motor Vehicles Act when there is criminal code sort of driving convictions, or even broader than that, sort of when there's criminal code charges and what happens under the Motor Vehicles Act. And same as Leo, this presentation, I've tried to make it so that it's a reference for you. It'll be posted on the Lost Sighting website once the presentation's done. But my goal was to try and create some sort of a reference document so that if you needed to, in your practice, you could go back to it. If you're negotiating some sort of a plea deal or something with the Crown and you want to make sure that you're not going to have your client have any unintended surprises at the end of that process. Do I do this? Just a sec, I need to figure out how to advance it. Okay, so I've just put the citations here for the couple different pieces of legislation that you will want to look at. Perhaps if you're dealing with this area, there's the Motor Vehicles Act, but then there's also the Motor Vehicles Regulation. And then there's the Administrative Sanctions Regulation. There's many regulations made under the Motor Vehicles Act, but these are the two that I'll touch on today. Before we start, I think it's important to know under the Motor Vehicles Act a couple of important terms. So an operator's license, which is what the Motor Vehicles Act refers to, your driver's license. It's the actions that can be taken on that license is it can be canceled, expired, or suspended. And really importantly, those are distinct things in the Motor Vehicles Act. So they're not the same. And they're all things that can happen to your operator's license. The most important distinction, I think, in my view, is that the disqualification is something that happens to the driver, so to a person. And so it's something that affects the person, not the license. And it's also distinct from something like a suspension or having a canceled or expired license. So you'll see all of these terms used throughout the Motor Vehicles Act, but they mean different things, and that can be an important distinction. I've broken down the Motor Vehicles Act driving restrictions into two sort of separate areas, one being things that can happen roadside. So these are things that happen to a person when the police pull them over, they're driving. And then the other three things is things that happen upon conviction. Importantly, not upon sentencing, but upon conviction. And so there's sort of three of each area. I'm going to take you through them. For roadside, the three things that the police can do in the territory is they have the impoundment provisions under the Motor Vehicles Act. There's the ability to do a 24-hour surrender of license request, and then there's a 90-day suspension or disqualification. And the distinction on whether it's a suspension or disqualification, I'll get into in that slide. So the first being an impoundment. So a peace officer can impound a vehicle if they have reasonable grounds to believe it's being driven contrary to any of these provisions. And sometimes it's several of these provisions all at once. Under the Motor Vehicles Act, having no license, no insurance, or being the driver being disqualified can allow the police to impound the vehicle. Under the Criminal Code, I've cited the new provisions, so the impaired operation or over the legal limit for drugs or alcohol, a refusal, fail to stop after an accident, flight from a peace officer, or operating while prohibited. So any of these provisions are going to potentially, and in my experience, yeah, they usually happen in combination, but those are going to get your vehicle impounded roadside, which may not affect your driving privileges, but it's certainly going to affect you right in the moment your vehicle's going to be towed. The duration of the impound is variable, and it's set out in the code. I should say that the vehicle, when it's impounded, it's stored at the expense of the registered owner. I've set out the fees there. It's $7 a day plus the tow cost, which can be significant, particularly if you're in the communities. And the vehicle won't be released until those fees are paid in full. And then the duration depends on whether or not there's been, whether or not it's a first impoundment or whether it's a second or a third or a subsequent. So the first impoundment is going to be 30 days. And then the 60 days if it's a second within 5 years, and then 120 days if it's the third or subsequent within 5 years. I should note that also if it's the third or subsequent within 5 years, the registration for that vehicle is also void and the vehicle will not be re-registered for 240 days. There is an escalation provision as well, which says that if the duration of the impound, the ones that we just talked about, that will be doubled if the peace officer has reasonable grounds to believe that if the driver's blood alcohol concentration exceeds 160 milligrams per 100 milliliters of blood, or if there's a refusal to comply with that with the demand under 320.27 or 320.28. And those impound durations are calculated by the motor vehicles branch. So it's not something that the peace officer has any discretion about. There is an early release from impound process that can be engaged. It's actually very frequently engaged. So a registered owner or a dependent, and it's a dependent of the vehicle. So usually someone who lives with the registered owner is dependent on the vehicle, can apply for early release. The statute uses the term review officer, which really is a judge or JP of the Territorial Court. And so those hearings are heard, they're often initiated by people unrepresented, but they're heard regularly in Territorial Court. And then there are provisions in 237 that set out what will justify a release. And the standard is a balance of probabilities for the review officer. Usually it's things like if you're the registered owner, but you weren't driving and someone took your vehicle without your knowledge, or you weren't aware that they didn't have a license. If you are a dependent and you can explain to the court and satisfy the court that you're dependent on that vehicle, and you'll have some hardship if the vehicle is not otherwise released. So the next roadside restriction that can be imposed is the 24-hour surrender of license. So again, this happens if a peace officer has reasonable grounds to believe a driver has consumed alcohol, drugs, or another substance, and that it's impaired their mental or physical ability to drive. What happens in that situation is the peace officer will request a surrender of the license, and they can also impound the vehicle for that 24-hour period. So the impoundment in that situation is not happening under 235 that we just talked about, it's happening under this provision. So the distinction with what happens, I should say, when there's a request to surrender your license, if you're a licensed driver, then what that's going to do is suspend your license for those 24 hours. If you're an unlicensed driver and you're behind the wheel, then it's going to disqualify you from operating a motor vehicle, because as we talked about, the suspension operates on the license and the disqualification operates on the person. And so if you're unlicensed, you don't have a license, there's no suspension to be given, so it's a disqualification. So then the other, probably the most significant roadside restriction that can be imposed is the 90-day roadside suspension, and that's happening under Section 257 of the Motor Vehicles Act. So again, it's a peace officer who can issue a 90-day roadside suspension if it's a licensed driver. It's going to be a disqualification if you're an unlicensed driver. So if it's an unlicensed driver behind the wheel, they're disqualified. And the reasons for that can be impaired operation, alcohol, drugs, or a combination. It's the 80 or over blood alcohol, a refusal of a demand, or if you are prohibited, disqualified, or your license is suspended already. So in those circumstances, they can impose the 90-day roadside. I've just set out in this slide sort of the different things that happen depending on the status of the driver. And so if you're licensed, something that's interesting in the Motor Vehicles Act that's, I don't think, very well understood, just judging by the questions I get about it, is that if the police do issue a 90-day roadside, what happens is there is, in certain circumstances, a 14-day temporary sort of grace period where the driver is essentially allowed to sort of get things in order so that they're going to, because they're not going to be driving for 90 days under this. So if you're licensed in Yukon, you're a fully licensed driver, what's going to happen is you will have to surrender your license, and the police officer is immediately going to issue you a 14-day temporary permit. And then you're going to be issued the 90-day suspension, which will start immediately after that 14-day temporary period. So you get 2 weeks of driving, even though you've been issued the 90-day. If you're licensed outside of Yukon, you're going to be disqualified from operating in the Yukon and applying for a license in the Yukon. And that disqualification takes effect 14 days from the date of the notice. So again, you're given that 14-day grace period to get things sorted. If you're already on a temporary permit, so it's not uncommon that somebody's already on a 90-day and then they get another 90-day, then your 90 day is going to start immediately and you have to surrender that temporary permit. So there's no 14-day grace period in that scenario. And then if you're unlicensed, you're just immediately disqualified, and you're disqualified from operating and applying for a Yukon license. There is a review provision for the 90-day suspension. Again, this is usually initiated by self-represented people, quite regular actually. So you can apply to revoke that 90-day. Importantly, the application to revoke is not a stay of your suspension or your disqualification. So until that's heard and decided, you're still either suspended or disqualified. It's heard by a review officer who is a judge or JP of the Territorial Court. And then the only issue at that hearing is whether the peace officer had reasonable grounds to suspend or disqualify under the Section 257. And that's on a balance of probabilities. I have just made a note here that at the revocation hearing, the fact that there's no criminal charges laid, or there's been a stay or a withdrawal or an acquittal or a discharge of any of the criminal charges that were laid, it's not grounds to revoke the 90-day. So now I want to talk to you a little bit about the driving restrictions that come into play under the Motor Vehicles Act upon conviction. And again, there's 3 ways in which that can happen. One is a disqualification for an impaired driving offense, and we'll talk about what the Motor Vehicles Act defines as an impaired driving offense. And then I've characterized this as sort of criminal driving offense, so something other than an impaired driving offense. And then lastly, demerit point suspensions, which are sneaky and come up more than you'd think and gum things up. So the first is a disqualification that can arise, and there we go, for an impaired driving offense. So if you're convicted of an impaired driving offense, then you are disqualified from holding an operator's license under Section 255. And conviction, I've just made a note, includes an absolute or conditional discharge. The Motor Vehicles Act defines what is an impaired driving offense, and it does include Section 266 charge under the Motor Vehicles Act. That's the drive disqualified provision, offense provision under the Motor Vehicles Act, and that it includes various criminal code provisions. Interestingly, it does not, there's some things that it doesn't include, but really it's been updated to reflect the 2018 amendments to the criminal code. It also makes reference to the ones prior to that. So the duration of the disqualification upon conviction, if it's first conviction, it's going to be a year, second is 3 years, third or subsequent, it is indefinite. And I've just made a note for the second or third or subsequent, it doesn't matter whether it's under the same provision or whether it's a combination of different. If it's an impaired driving offense as defined under the Motor Vehicles Act, it's going to be subject to these durations based on the number of convictions. If there's more than 5 years between the offense that results in the following conviction, then it won't count as the subsequent or second or subsequent. And then there is a provision in the Motor Vehicles Act that the court can make an order increasing the length. There's no ability to decrease below these, but the court can increase. So this is something that I think is perhaps, if you take 1 point away from this presentation, hopefully this will be it. This is the area where I get the most calls or questions, and it's usually after the fact when people are like, I don't know what happened here. The 255 disqualification for an impaired driving offense, it arises upon conviction. And so it's not at sentencing, it's when you're convicted. And it also arises by operation of law. What that means is that the court doesn't have to specifically impose it. It's not, and I think in lots of cases it's happening, or it's not addressed at all by the court. But what happens is under the Motor Vehicles Act, the registrar has no option but to impose the disqualifications. It's not a discretionary action that the registrar has under the Motor Vehicles Act. There is a provision indicating that the convicting judge is required to inform the convicted person that they're disqualified from holding a license and that they must surrender the license that they hold. But then it does go on to say if that doesn't happen, that doesn't affect the validity of the disqualification. And the last point, which I think is important, is that there is no provision in the Motor Vehicles Act to stay the disqualification pending appeal. So if a person gets convicted of an impaired driving offense and there's this disqualification kicks in, and then there's an appeal, even if there's a stay of the prohibition that was imposed by the lower court and a stay pending appeal, this disqualification is still going to be in effect. And there is a recent decision, it was given orally by the Supreme Court, Justice Campbell, and we're waiting on the written reasons, but recently that exact scenario played out where you had somebody who was convicted of the first time impaired driving, and they received a prohibition order and sort of the minimum fine, I think it was, and then that was appealed. And there was a stay of the prohibition, but that the accused was very unhappy when they received a letter from the motor vehicle branch saying you're disqualified from operating a motor vehicle under Section 255. So their counsel contacted me, and we'd had some discussions, and ultimately we ended up back before the Supreme Court in a hearing to determine this issue. And what was being asked of the Supreme Court was to use its inherent jurisdiction to essentially set aside the disqualification pending appeal. And ultimately the court found it could not do that under its inherent jurisdiction, and that the disqualification under the Motor Vehicles Act happens by operation of law. And so it's something that was beyond the court's reach. And so not a very happy outcome for the person who had been under the impression that they could drive because of the stay being in place.
Kelly, sorry, I'm just going to interrupt because we had a question come in from Chandel, and she's asking, what is the reasoning for including drive while disqualified as another impaired?
Well, I can't say specifically what, I mean, I know it's been in the Motor Vehicles Act for a long time, that provision. I don't know the true, truly, I don't know sort of why it's been lumped in with those offenses, but I think it's, what it does is it essentially creates the disqualification, like it brings in the disqualifications that would otherwise arise. I would say drive disqualified is probably one of the most serious charges there is under the Motor Vehicles Act. And I think probably it's connected in some ways to the fact that a disqualification typically arises because of an impaired driving offense, other than other charges that might arise in different ways, if that makes sense. But really, I don't truly know the policy sort of rationale for that. So I'm going to move on to the disqualification for other criminal driving offenses. This is found under section 260 of the Motor Vehicles Act. It's really captures other criminal code offenses such as dangerous operation, criminal negligence causing death. It has to be with a motor vehicle, criminal negligence causing bodily harm, again, with a motor vehicle, or manslaughter committed with a motor vehicle. And so these are the other criminal driving offenses that will give rise to a disqualification. Same as in section 255, a conviction also includes an absolute or conditional discharge. And then the court can make an order increasing the length. I should say with the other, for other criminal driving offenses, the length is 3 months. So it is a 3-month disqualification that arises unless it's increased by the court. Similar to 255, this is a disqualification that arises upon conviction by operation of law. There's the provision that the convicting judge is required to inform the accused that they're disqualified and that they must surrender their license. And there is no provision in the Motor Vehicles Act to stay the disqualification pending appeal. I should say that the reason that's important is because I know we have practitioners who are called to the bar in the Yukon who practice in BC. And it's an important distinction because in BC, their provincial statute does have the provision where you can stay a disqualification or a restriction on a driving privileges pending appeal. But that is not the case here in the Yukon. I recently, I'll just tell you one short anecdote, which is under 260. Last week, actually, I was doing a case with the federal crown. It was a joint prosecution. There was motor vehicle charges and criminal code charges, and the accused was ultimately convicted. And there was going to be a delay in the sentencing. It wasn't going to happen right away. And there was a bit of a discussion initially with the court and the parties about this accused, or this person who'd been convicted. They had been driving under bail conditions that they were allowed to drive only for work. So there was a discussion about whether or not that could continue until the sentencing was done. And I had to bring to the court's attention this provision, which essentially means if you're convicted, it's right away. So there was no need, and there really wasn't the ability to have any discussion about whether or not this person could continue to drive. Because really what ended up happening is Judge Chisholm informed the person that they were disqualified right away by virtue of this 260, and they had to surrender their license immediately. I think I sort of went over this, but this is, I think, an important slide for to consider when you're negotiating, if you're negotiating a plea on a criminal code driving prohibition order. And so if you're talking about the length of a prohibition order, the period of disqualification under the Motor Vehicles Act, if it's under 255 or 260, either one of those, it's the longer of the period of time that's set out in a prohibition order, if there is one, or the period of time specified in 255 or 260. So I can imagine that might be significant if you're talking about negotiating with the Crown or in defense, or negotiating a term of a prohibition order, because if you're going to have a disqualification under the Motor Vehicles Act that's going to be for 2 years, it may not really matter if you're going to have a 1 year or an 18-month prohibition order, because you're going to, either way, that individual's driving privileges are going to be disqualified under the Motor Vehicle Act provisions. So need to remember that it's the longer of those two that's going to be applied by motor vehicle branch.
So just a question on that, Kelly. When it says period of time in the order, that's the actual number that's in the criminal sentencing court's order.
The
right?
prohibition order.
Right. Because I've had a case where the person had been on bail with a no driving condition for so long that their driving prohibition was actually all used up by the time they got to sentencing. So they had no driving prohibition, even though it was mandatory and considered that it was already served. So in this scenario, then it would just default to the period specified in 255 of the Motor Vehicles Act?
Exactly. Yeah, but if there is going to be a prohibition order, and I know sometimes that's the subject of negotiation, it might be important to know if the concern is simply how long will this person not be able to drive, that important to know that you need to understand the period of the disqualification, because it could be that it doesn't matter if the prohibition order is going to be a set amount, this amount, because the disqualification is going to make it longer.
Right.
So I've also put in there, when you're disqualified, the license that you hold is also suspended, which has also affected people if they require to have a license for their employment, even if they don't have to drive. Sometimes there's a term of condition of your employment that you have to have a valid license. Now, I'm just trying to, under 267, there is the ability, if a conviction is appealed, that the suspension will not apply until the conviction is sustained or the appeal is abandoned or struck out. This provision only applies to suspensions though. And this was something that was looked at by Justice Campbell in the decision that I'm hoping we're going to get written reasons very soon on. Because there was a suggestion that this provision would be sort of an avenue to get rid of the disqualification, but the court made very clear that it's the Motor Vehicles Act, a suspension is not a disqualification. They aren't equal terms. They're used differently and they do different things. And so there's only a provision if there's an appeal to have a suspension not be applied, not a disqualification. There are ways in which a disqualification can be removed, and we're going to hear more from Julius about the Driver Control Board, but the Driver Control Board is the entity that can remove a disqualification either under the impaired driving offenses or under the other criminal driving offenses. And for a first conviction, there's no waiting period. For a second conviction, there's a 2-year waiting period, or for a third or subsequent conviction, it's a 5-year waiting period. And that's just to apply to the Driver Control Board. I have some information here. I think we're going to hear more from Julius about the Driver Control Board, but the Driver Control Board can remove a disqualification if the driver agrees essentially to obtain, maintain, and use at their expense a motor vehicle that's equipped with the ignition interlock program. And the waiting periods, there used to be a waiting period even for a first conviction, but now the Motor Vehicles Act was recently amended last year in December to align with the criminal code. So there is no waiting period for a first conviction, unless there's one fixed by the court specifically. And then it's 3 months for the second conviction and 6 months for the third or subsequent. So that's to enter into the alcohol ignition interlock program. Importantly, just to know is that the removal or expiry of a disqualification doesn't automatically mean that someone's license will be restored. So the Motor Vehicles Act makes it clear that the registrar can't issue or reissue a license until the period of disqualification has expired. And then once the disqualification is over, you've been convicted, you've done your, say, 3-month disqualification, you have to apply again for a license. And you also have to pay any outstanding Motor Vehicle Act fines. So that I have seen be a real barrier, or something that people don't appreciate. They just think that their disqualification day ticks by and then they can start driving again. You actually have to take some active steps to institute your license, get it back in good standing. And sometimes that involves paying outstanding Motor Vehicle Act fines, even if they're totally unrelated to why you were disqualified. You have to make sure that you've paid any MVA fines. The last thing I just wanted to touch upon, because I think it's something that probably in the criminal realm isn't on the radar at all, but I have seen this create some unhappy surprises for people, is the demerits point suspension system. So it's set out in the Motor Vehicle Act regulation, section 9, Again, it's automatic upon conviction, and it's done by operation of law. So the court doesn't have any ability to do away with the demerits, neither does the registrar at Motor Vehicle Branch. This is done all by under the Motor Vehicles Act regulation. So 15 or more demerits on your license is going to give you a 1-month suspension of your license. And it's 7 demerits if you're a graduated driver, which means you're still not a fully licensed driver. You're on the graduated driver's licensing program. If it's a second demerit point suspension within a year, it's going to be a 3-month suspension of your license. If it's the second or more demerit suspension within 2 years, it's going to be a 6-month suspension of your license. And each criminal code impaired driving offense is worth 10 demerit points. So that's all set out in the regulation, and that's important because if you've got any, if you've got a couple speeding that you've got, you've accumulated a few demerits, one impaired driving offense is likely going to push you into a suspension. And so that can be a very unhappy surprise for people when they think that they're not, they don't have any restrictions on their driving, only to get a letter from the registrar saying, by the way, you're over your demerit points and you're now suspended for a month. And important to note too that an appeal does stay the suspension, again, because it's a suspension. So if a conviction is appealed, until that appeal is resolved, the demerit points won't be allocated. The last thing I just wanted to touch upon was the offensive drive disqualified under the Motor Vehicles Act. This is the one offense under the Motor Vehicles Act that is also included in the impaired driving offense provision. And what it does is it also sets out a number of things under which a person would be deemed to be driving disqualified. And that can be if you're subject to a 90-day roadside suspension, if you're then caught driving, that's a drive disqualified. If you're contravening a condition under which the Driver Control Board has removed your disqualification, or if you're driving in contravention of the interlock program that you're entered into, or if you're disqualified by the registrar under section 20 or 18, and 18 is the medical disqualification. That commonly arises with somebody if they've had like a seizure or something and they have a medical disqualification on their file. If you're driving contrary to those, a disqualification under either one of those provisions, it will be a drive disqualified charge. Or if you've been ordered by the Driver Control Board to complete a remedial program and you haven't done so yet and you're driving, then those are all deemed to be driving while disqualified offenses. Just touch on a few of the amendments that happened to the Motor Vehicles Act in December of 2021. Really, the purpose was to align them with the 2018 amendments to the criminal code. It was still referring to the old provisions and whatnot. A couple of things that was done is they added the ability for a peace officer to impound for 24 hours after they issue a 24-hour roadside surrender of your license. That's new. It changed exceeds 80 to equal to or exceeds 80. It also allows for a 90-day roadside if reasonable grounds that the driver is impaired by alcohol, drugs, or a combination. And then what it didn't do is it did not bring forward the fail to stop after an accident or the flight from a police officer into the 260 disqualification provision. So the former provisions for those were in that disqualification. So a conviction for failing to stop after an accident used to be something that would give rise to a 260 disqualification. Those two offenses were not brought forward. And the only reason that I suspect that was done is because there was elements of those two offenses that were changed in that you no longer have to be like flight from police officers no longer required, Crown's no longer required to prove that it was to avoid liability. So I suspect that there was, because the elements were changed, that it wasn't a straight across realigning just with the provisions. So those are not currently convictions under 320.16 or 320.17 will not give rise to a 260 disqualification. And then the last thing that it did, which I already mentioned, is the amendments just remove the waiting period for a first conviction for the alcohol interlock program. So thank you very much. I'm going to pass it over to Julius now to talk to you about the Driver Control Board.
Kelly, while Julius is getting set up, I actually have a question.
Sure.
You mentioned that the offender has to pay any Motor Vehicle Act fines before they can get their license back. Do you know, would that include fines issued under the criminal code? So,
No, the provision is specific to Motor Vehicle Act fines.
okay.
So the registrar can't reissue your license unless you've paid all your Motor Vehicle Act fines. So, so if a fine under the criminal code or any other provision would not mean that they couldn't reissue your license.
Okay. And thank you. And perhaps on behalf of everyone, because this is a complicated area, do you mind if council contact you with questions about the Motor Vehicle Act and how it interacts with the criminal code?
No, not at all. That's why I put my contact information at the end. I'm happy to have a call. I often get calls from council just asking me sort of what would happen if I'm trying to negotiate this with the federal crown, and what would this do, or what would happen to my client's license? And I'm happy to work that through, or to, if I don't know the answer, to help figure it out. I'm fine with that.
Okay, thanks very much. So now it's over to Julius.
Good morning, everybody.
You might just need to go to the down lower corner. No, just right here.
Thank you. Obviously, some technical difficulties with me this morning. I realize you'd probably rather be where this photo was taken than sitting here and listening to me. For those that are not initiated, this photo was taken about 40 years ago in the Valley of the Temples on the island of Oahu, and it's certainly a nice spot, especially this time of year. No. Let me just explain briefly what the Driver Control Board really is. So we are a 5-member quasi-judicial board, and we have a medical advisor on hand as well. He doesn't come to each hearing, but he's there at least for one hearing a month. And right now, that is Dr. James Van Camp from the Whitehorse Medical Clinic. We're appointed by Commissioner in Executive Council. We're mandated under the Motor Vehicles Act. We carry out an adjudicative role in determining if an individual may hold a driver's license. And as of April 20th, that's the last time I checked, we had 1,141 active files. Now, that includes clients that must be monitored for conditions that we apply. And that could be from anywhere from 2 years to life. That's the range of our conditions. So there are a lot of files. And of course, it also includes people that are still waiting to see us. We had quite a backlog because of COVID. That's slowly being eased, but we're dealing with an awful lot of people. And our primary concern, of course, is public safety. Now, I'm just going to, this is really causing me some problems here. Our mandate comes from the Motor Vehicle Act. And rather than boring you with this, you can look this up quite easily. Again, this presentation will also be on your website. The functions of the control board. Anytime a judge or registrar considers an inquiry should be made into whether any person should be permitted to hold an operator's license, a judge or the registrar may report the person to the Driver Control Board, and the board, after due inquiry and in interest of public safety, may then suspend the operator's license of the person for a definite or indefinite period of time, prescribe any measure or course of remedial education or treatment as a condition of the possession of an operator's license, and prescribe terms and conditions for the possession of an operator's license. No, I'm going backwards here. How do I go back?
Can I help?
Yeah.
Where can I go?
Yeah, functions here.
Functions.
proceedings. The functions of the Driver Control Board, on receipt of a report, the person shall notify, or the board shall notify a person in respect of whom the report was made as to whether the board proposes to act on the report or not. And if the board proposes to act, we must inform the person of the date being not less than 10 days from the date of notice. The board, we also explain where the hearing is going to be held. The person shall be entitled to make representation at the meeting to the board and be heard in person or by counsel or agent. Now, I have to say a little bit on that later on. Whatever the case is, we must hear from the client. We can't have a legal representative come and take the place of the client, although the legal representative may accompany the client and ask questions on the client's behalf. The board shall not suspend or restrict an operator's license of a person without giving them at least 10 days notice in writing and giving them the opportunity to be heard in person or by counsel or agent. And in making a decision, the board may take into consideration the person's accident record, conviction record, driver attitude, driving skill, and knowledge driving disabilities. And knowledge, driving disabilities, and any other factors it considers relevant. Now, we, on the last point there, the Yukon Territory is a little bit different than some jurisdiction in that we consider the lifetime driving record of our clients. If a client comes to the Yukon from another jurisdiction, then that jurisdiction's driving record will be considered as well. And if they've been living in 2 or 3 or 4 jurisdictions prior to coming to the Yukon, all those driving records will be accessed by us, and we will take a look at it and consider them. Next, we go to the appeal from a decision of a registrar. Any person who has been refused a license by the registrar or whose license has been suspended or canceled by the registrar or the minister may appeal the refusal, suspension, or cancellation, as the case may be, to the Driver Control Board. And the person who wishes to appeal a decision of the registrar under this section shall, within 30 days of the date that person was served with a notification that they were refused a license or that their license was canceled or suspended, serve the Driver Control Board with a notice to appeal. That usually happens, the latter part where they appeal, it usually happens with medical disqualifications. And we'll go into the medical stuff in a little bit. Nope, I'm going backwards again. Appeal from decision of a registrar continued on being served with a notice of appeal under subsection 2. The Driver Control Board shall, within 30 days of being served with a notice of appeal, hear the appeal. So we can't push that off. We have only 30 days to hear the appeal. And on hearing an appeal under this section, the Driver Control Board may confirm a decision of the registrar, order that the license be issued, remove or vary the suspension, or reinstate the canceled license. Now, summoning a person before the board, the attendance of a licensee or witness before the board may be enforced by notice issued by a member of the board, requiring the licensee or witness to attend and stating the time and place at which the attendance is required. And there's normally a form letter that happens with. Any member of the board may administer an oath to any person who's to give evidence before it. A person who A, fails to attend before the board in obedience to a notice to attend, or B, who, being a witness, refuses to be sworn or to answer any questions directed to be answered by the person presiding at the hearing of the board, is liable to the attachment on application to a judge of the Supreme Court and may be proceeded against as far as civil contempt of that court. Now, subject to the regulation, testimony may be adduced before the board in any manner the board considers proper, and the board is not bound by the rules of law concerning evidence applicable to judicial proceedings. Now, we've run into cases, not very common, but we have had issues where some clients refuse to testify about an incident that led to their charge or conviction, often on the advice of their lawyers. And while we accept that, I can tell you that it's very difficult for the board to arrive at a totally fair decision in that case, because we don't know all the circumstances of what happened at the time of the offense. So often they say, well, I can tell you about my drinking habits if it's an impaired charge for alcohol, and what has happened since I've gone to court, or what happened since I've been charged and I'm still waiting for a court case, so I can't explain anything that happened on that day. You must realize that whatever happens in the hearing does not affect what's going on in court. We don't share our hearing notes and our decisions with the court. We share it only with motor vehicles, of course, the client, and then the client can share it certainly with his or her lawyer. But we will not share our findings with the prosecution or a judge unless we get a court order. And I don't think that's ever happened in the Yukon.
Julius, before you move on, we had a question,
Sure.
which is whether there are any regulations promulgated under section 24 sub 4 governing practice and procedure, et cetera, before the board.
I didn't quite hear what you were saying there. Sorry.
I was saying the question is whether there are any regulations promulgated under section 24 sub 4 governing practice and procedure, et cetera, before the board.
I don't think there are that I'm aware of.
Concise answer. Thank you.
Now, review and appeal. If the board has suspended the operator's license of a person for an indefinite period or for a period in excess of 6 months, the person may apply to the board for a review of the suspension, and the board shall, within 30 days, give the person an opportunity to be heard. No person may apply for a review under subsection 1 more often than once every 6 months. And on a review under subsection 1, the board may confirm, modify, or set aside an earlier decision by it. Still under review and appeal, any person who considers themselves aggrieved by a decision of the board may, within 30 days after the decision of the board is sent to the latest address, as recorded with the board, appeal the decision of the board to a judge. And the judge may confirm, modify, or set aside the decision of the board. Referrals to the board. Usually, clients are referred to the board by the Registrar of Motor Vehicles. The registrar may refer clients after receiving court documentation, requests from a judge, from a physician, the RCMP, or for significantly poor driving records. And what usually happens is the Registrar of Motor Vehicles sends a letter to the board referring a client, and it's a standard letter, and I'll post that on your website as well. And there's a different section for each of the following. There's a section that deals with the graduate driver's license holder, so people that are still starting out or just starting out. Then no GDL holder or non-GDL holders, that is everybody else that has a full driver's license. And then there's a little section there concerning unlicensed individuals who reside in the Yukon, and each of those have different things that we look at. Probably the toughest, of course, are graduate driver's licenses. And we have, surprisingly enough, we have quite a few people showing up to the Driver Control Board hearing who are still on a GDL, which is kind of sad, really. Clients may also refer themselves to the board for ignition interlock. In other words, if they want to get the license quicker, the disqualification ended quicker, and they want to take part in the IIP or the ignition interlock program, they can certainly contact us and set up a hearing, and then we'll listen to them and consider their question or their request. Medical referrals are discussed when the board physician is present as a rule, and there's a standard letter that goes out if somebody is disqualified because of their medical conditions. And in the letter that goes out, in the form letter that goes out, there's also a little paragraph that says that the person or the client can appeal this cancellation to the Driver Control Board, and it gives the phone number where they can do so. And if an appeal like that shows up, again, we certainly make sure that the physician, our board physician, is on hand to hear that appeal. Clients disqualified by the Registrar of Motor Vehicles for medical reasons may appeal the disqualification to the board, as I said, but they must do so within 30 days of the disqualification. And in addition to that, they must include medical release information. That means the board can examine the client's medical records and or ask the client pertinent questions concerning their medical issues. And quite often, people kind of don't really like the idea too much, or they think, you know, it's a breach of privacy. But I can tell you that in many cases, it works in favor of the client. Again, unless we have full disclosure and knowledge of what's going on, it's very difficult for us to make a fair decision. Reciprocity, I'm afraid there is only reciprocity between all Canadian jurisdictions when it comes to the ignition interlock program. That said, Ontario can be a little bit difficult to deal with at times when it comes to reciprocities. That's our experience. And although Alaska and about 30 of the US states have systems similar to our ignition interlock program in place, there is no reciprocity between the US and Canada in place. So our interlock program is not accepted there, and the US interlock program is not accepted here. Now, talking about the ignition interlock program, or IIP, and Kelly has covered a little bit of this already, but I'll just go over the basics here. Ignition interlock provides a device that requires clients to provide a breath sample before and while driving. Clients can apply to take part in the IIP right away after the first conviction. That has been changed now. And again, the second conviction within 5 years, within 3 months wait, or after 3 months wait, and the third conviction within 5 years after a 6 month wait. The device must be installed for 6 months or the end of disqualification, whichever is longer for the first offense. For the second offense, it's 30 months or the end of disqualification, whichever is longer. And for the third and subsequent offenses, it's 5 years or the end of disqualification, whichever is longer. The time starts counting after the road test with the device installed. So what happens is if a client is approved by the board, they phone our board coordinator, set everything up, the device gets installed in the vehicle, and then they take a road test to make sure, it's not your usual class 5 road test, it's a road test to make sure that they know how to handle the device. And once that road test is completed, then the time starts counting, the 6 months, the 30 months, and so on. The last 6 months of the interlock program must be totally free of any alcohol-related fails. And it's important to note that the client can only drive the vehicle that the interlock device is installed in. That vehicle also can be driven by other people, but they must provide a breath sample as well. And the IIP device can also be installed in commercial vehicles. Now, intoxicants other than alcohol don't really register on the IIP, on the ignition interlock device, but certain foods certainly do. So we warn the clients, and there's a list of do's and don'ts that they get when they enter the IIP program. We warn them that, for example, pizza or nuts, anything that has yeast in in the food, can set off the interlock device. Mouthwash can do that, and even windshield washer fluid can set off the device. But we recognize that, and usually within if they restart or retry the breath sample within 5 minutes or so and get a pass, then it's not considered a fail. What we advise clients to do is carry a bottle of water with them. So if they for some reason blow or fail after eating, they just rinse their mouth out, wait for 5 minutes, try again, and there shouldn't be any issues whatsoever. If they suspect it was because of the windshield washer fluid, they can then air the vehicle out for 5 minutes, try again, and usually they don't have any problems. We also have an impact program in the Yukon. Clients can only participate if they're referred to and registered by the board. And I'll just, let me just find this here. I'll tell you what impact is, and what it stands for, and it's information and motivation for positive action and choices today. That's that's what we call impact instead. It's a little bit shorter. It's administered through the Yukon University. Impact is paid for by the Driver Control Board program. So it's not by the clients, although that may change in the future. When registering, clients get all the information pertaining to their file, and they get a little outline of the program, and they have to sign a form or an agreement that they enter into that says that they have to be showing up totally sober, that they can't be disruptive in class, and so on. The impact must be completed within 1 year or prior to license reinstatement. Classes are held once a month over a 2-week period, except in July and August when the university takes a break. Clients must attend 4 group sessions, 2 hours each evening, twice a week for 2 weeks. And there is homework required. Maximum space per class right now is 12 clients. Clients who are registered for impact and then don't show up for any of the sessions without prior notification will be suspended indefinitely by us, unless the reason for not attending is a valid one, such as illness, family emergency, or other mitigating circumstances. But if they just fail to let anybody know that they're not coming, then automatically they're suspended again. And the reason for that is we've had so many problems with people not showing up that we were forced to do something because of the limited space we have for clients. You know, if you have 1 or 2 clients that decide they'd rather not show up, that takes the space away for other people that are on the waiting list.
Julius, before you get
Yes.
too far away from the interlock slide, I wanted to ask 2 questions about it. First, I've had judges before after sentencing or at the tail end of a sentencing hearing recommend the offender for the interlock program. Does that recommendation get conveyed to you? And if it does, is that taken into account in your decision?
Everything that happens pretty much comes through the Registrar of Motor Vehicles. So eventually, if it's recommended, it would come to us. And we'll certainly consider whatever court has to say. We'll never ever overrule court, obviously. But if they're recommending it, most people are quite keen on participating in the ignition interlock program because it gives them a chance to start driving again.
Right, of course.
So it costs them money. That's the other thing that I didn't really cover yet. But yeah, most of them are quite keen.
And that actually relates to my second question, which is, I think I've heard that there's a limited amount of interlock devices in the Yukon. Is that true?
Limited number of places that install the device?
I heard a limited number of devices available, but I mean, I'm not sure if it's true or not.
No, there's not a limited number of devices available. What is happening right now, I wish I could talk money with the people that are participating in this program, but we're just right now negotiating a new contract with Alcoloc, that is the provider of the interlock program. And it used to be roughly between $450 and $500 for installation and the first month, and then $150 a month thereafter. Now we're looking at shop rates, various shop rates that will come into the picture. And I can't give you a good number right now because I just don't have that available since we're negotiating. But you know, there's plenty of devices to go around, and I'm not aware of any case where people had to wait extra because there was not a device available.
Okay, thank you.
Okay. Now, one thing about the impact program, there's a similar program in almost every jurisdiction, and Yukon Territorial will definitely accept impact courses from other jurisdictions. Although they might have different names, but they do exactly the same thing. There's a course in Alberta that is held on one day instead of having 4 evenings. It's one day, one long day, and we accept that as well. So some clients choose to go down there instead of being tied up for 4 evenings. They choose to go to Alberta if they're going down there on business or holidays anyway, take the impact course there, come back, provide us with proof, and we accept that. Driver Control Board suspensions. When the board receives a referral, the client will be notified of the planned hearing by mail no later than 10 days prior to the scheduled hearing. If a register letter is returned, notice is deemed to have been served. And quite often we have people that don't show up to our hearings, and then we find out they've never picked up their mail or they've moved in the meantime. Well, we have no way of knowing that unless they've changed the address with motor vehicle branch. So we send out our letters to the last known address, and that's what we go by. If a previous decision states that a client can be suspended when ignoring conditions, the client can be suspended immediately. There is no 10-day notice required. So if we have a decision, for example, that says no intoxicants or alcohol within a 2-year period, and they get caught in a 24-hour suspension, automatically, the moment we find out, that client is suspended. They don't get 10 days notice from us. Suspensions are always indefinite. For example, until the client has completed impact, court proceedings, whatever the case may be. And sometimes we see clients that come to us, they had say a 90-day suspension. They come to us prior to court. And that makes it interesting for us because we don't know what the outcome of court will be, of course. And quite often, we look at the record, as I said before, we look at everything that we can find on this client. And if we deem the client a non-threat to public safety, we may well allow that client to keep the driving privileges until the court proceedings are done. And then, of course, it depends on court what's going to happen next. So it's not really called an interim license, but we allow them to keep their driving privileges until court has been finished, and then we'll take it from there. And we always let them know that after the court proceedings have concluded, there may be extra conditions that we apply to the driving privileges. So it's not used that often, but we certainly have that capability. Clients who possess a GDL or graduated driver's license when convicted must start out with the GDL again. And that's in Yukon, that is an 18-month period. So let's say they're in month 17 of the GDL period and they got nabbed for something that we need to see them about. Well, automatically they will start all over again. And clients will need to restart the GDL program if at any time they violate the GDL restrictions and conditions of class 7 or class 5. So in addition to that, if we say that, let's say a 2-year a 2-year period where they are not allowed to have any alcohol in the system when they get caught driving. We have the 18 months to begin with, plus after that, our 2-year sanction will start. So our sanctions normally start after the GDL period has been completed. And when we have a decision made, then it's usually sent out to clients within 10 days of the hearing. That's our aim. Sometimes it's 11 days, but we usually try and get it out within 10 days. And it's in writing, and it's quite a detailed letter so they can see exactly what was considered, what we consider any aggravating factors or mitigating factors. They're all listed in the letter that goes out to the client in the decision. And again, as I said before, and it's really important to remember, we don't share the record of decision with court or with prosecutors, only with the client and motor vehicle branch. And then if the client decides to share it with their lawyer, which often is the case, of course, they're free to do so, but we will not send it out to their lawyer. Now, I've talked about conditions, and the board doesn't just issue suspensions, rather it can also impose conditions. And often that is in addition to suspensions, such as 0 tolerance for alcohol and other intoxicants, 0 tolerance for motor vehicle act convictions, depending on why we see the client or what their driving record is like. And even if we have somebody that comes to us because of an impaired charge or conviction, if they're, the driving record is pretty poor, we might decide, well, we'll give them, say, 2 years, 0 tolerance for any motor vehicle act convictions. And we have such things as daytime driving only and other conditions that the board may see fit. For example, we may decide that we send a client for another medical if there was an issue with medical conditions, or a vision test, or maybe a road test in the future. And that's often done after discussion with the board physician, of course. We've had some people where, they pretty much admit to us that they don't see too well at night. And of course, then we have the daytime driving only sanction put onto their record of decision as well. And in certain cases, such as a medical disqualification, if people come and appeal, we don't send them a whole long record of decision. It's often done by a letter that outlines exactly what they need to do and what the decision of the board has been. Then we come to state charges. When the court stays the charges against a client who has been referred to the Driver Control Board, the board will usually not issue a suspension unless the client didn't show up for the scheduled hearing. And by the way, if a client fails to show up for a hearing, they're automatically suspended. We have to see them, so they need to come. However, certain sanctions or conditions may still be attached to our decision, even though the charges were stayed. And before a suspension and or conditions are issued, the board will consider the reason for the current referral of the client, but it will also include any prior convictions, Driver Control Board decisions, and medical conditions, if warranted, in the discussion leading up to the decision. Now, as far as the future goes, I'm not too sure what's going to happen. Of course, I don't have a crystal ball, but we know that the new Motor Vehicle Act, which is still a work in progress right now, may very well result in some changes to how the Driver Control Board operates. Depending Motor Vehicle Act is reflective of the waiting periods for ignition interlock participation required by the Criminal Code of Canada. Before we had the issue with the waiting period after the first offense. As Kelly mentioned, we have straightened that out and they can apply immediate. There's also a really good possibility of changes coming to the ignition interlock program. As I mentioned, we're renegotiating our contract with Alcalock, though I'm not too sure how far-reaching they may be. Certainly, the financial aspect is something that will come into the picture. The other changes are probably not that important. But cost is always a consideration for the clients. And like I said, up to now, we've kind of undercharged the provider or the people that install the ignition interlock device have often complained about not getting paid enough, and we're trying to fix all that. One thing I didn't do on my slides or anywhere else is provide the phone number for the driver control board. And if you want to take note of that, it's 867-667-5623. So if you have any issues or your client have any concerns or questions, they can phone this number and talk to our coordinator, and they'll certainly get steered in the right direction. And unless you have any more questions, we are coming to the end of this program, and like this bear does, I'll be out of here. Thank you.
Thank you, Julius. I'm just going to issue one last call for questions for any of our presenters. Okay, I'm not seeing anything, so I want to say a big thank you to our presenters today. Hopefully everyone found the session informative. I know I definitely did, and hopefully we'll be able to give better legal advice to people who are facing these kind of sanctions. So thanks very much.
Thanks, Lauren.
Thanks, bye.
everybody.
Thank you. Bye.